we just finished talking through the timeline, is that correct?
Correct.
I want to talk a little bit about some of the items that you located throughout your investigation and where they came from. Throughout your investigation, were you able to make a determination where any of the pieces of evidence located with Tara and Uriah had come from?
Yes.
Can you tell me a little bit about that?
The items in Laredo that were recovered, there was a box with ammunition, and it had the same initials, the JK written in black Sharpie on one of the boxes. That was the same as the magazine found by Tara's room in the house.
And what about the firearms that were located with them in Laredo?
The firearms, we knew that J.C. King was a gun dealer. He owned a store, and upon his death, he left all those items to Tammy.
And so the firearms that were located with Tara and Uriah, who did those belong to?
Tammy.
Besides the firearms and ammunition located with them in Laredo, what else, if anything, was located with them in Laredo?
There was also some money. There was items like a watch, a gold watch, but things belonging to Tammy, as well as some expensive guns, ammunition, magazines, money, and there was so much that we recovered.
I want to break it down a little bit. So with the money, how much money ultimately was recovered in Laredo?
$5,400.
And do you recall what denominations that money was in?
Yes, there were hundreds.
And do you know from your investigation, was that the entirety of the money that was taken from Tammy?
That was not.
So how do we know what that money came from or what it was?
They left, Butch left, or J.C. King left an inheritance to Tara in the amount of $10,000.
And where was that located?
In the gun safe.
And so you stated there was only $5,400 with them in Laredo. Through your investigation, did you determine where the rest of that money had gone?
Yeah, yes.
Where was that?
Along the way, they paid people to transport them or take them to the store, or and they paid with that money. They would give them $100 here and there just to get them things and get them to places.
And is that including people like Christian Atkins and Travis Hodge?
Yes, and Nathaniel Anderson.
So, besides what you located in Laredo, was there anywhere else that you located evidence that belonged to Tammy?
Yes.
Where?
In Travis Hodge's unit, storage unit, unit 191.
And what did you locate?
We located 2 guns and some ammunition, a bag of ammunition with some magazines in it.
And were these more of those same guns that used to belong to J.C. King that then belonged to Tammy?
Yes.
Other than now in Laredo and Travis's storage unit, did you pull any evidence from anywhere else that also belonged to Tammy?
I don't recall.
Did you locate any firearms or ammunition at Christian Atkins' house?
Yes, we did. We recovered some guns there.
And did that ammunition still have that same JK initials on it?
Yes, that's where we found the box that had the JK on it.
Now, were you able to determine where all of that was usually kept?
Yes.
Where?
In the safes in the Tammy's room.
And were you able to make a determination or find any evidence that told you whether or not Tara and Uriah had permission to get into those safes?
Yes.
How was that?
The passwords were written down on a piece of paper that were taped to the inside of her dresser drawer.
And so, was there anything else that told you that they weren't allowed to, that they didn't have permission to have those items?
Yes.
What was that?
We located a photo in the phone that had it was the same piece of paper that was still at the scene.
So they had taken a photo of those safe codes?
Yes.
We've also seen a lot about some communications via Instagram and text message. Did any of that give you more information as to whether or not Tara or Uriah had permission to have the guns or the money or the coins or anything of that nature?
Yes.
Can you tell us a little bit about that?
There was a message recovered that they stated they were going to rob Tammy.
And did in fact they talk about that multiple times?
Several times, to rob and kill her.
Now let's talk about, you stated to kill her. How many messages did you locate discussing Tara and Uriah's desire to kill Tammy King?
So that was one of the keywords we used in the Instagrams. We used kill, and there were several messages where they used the word kill.
And then did any of the evidence that we collected or that was tested by the lab, did that corroborate what you were seeing in the text messages?
Yes.
Can you tell us a little bit about that? What was it?
So the projectile located in Tammy's body that was removed by the medical examiner was consistent with the casing, the shell casing found in Tammy's room, which was located by her bed.
And we were able to match that to this firearm, correct?
Yes.
And where was that firearm ultimately located by Galveston County Sheriff's Office?
It was an AR-556, and it was located in Travis Hodge's storage unit.
And who gave it to Travis Hodge?
Tara and Uriah.
At the end of your investigation, did you make a determination whether or not a crime had occurred?
Yes.
What crime was that?
Capital murder by the way of robbery.
I'll pass this witness, Your Honor.
No questions.
All right, thank you. You may sit down. I call your next witness.
The state of Rush, Your Honor.
Have any witnesses?
We rest, Judge.
Okay, so both sides rest and close.
Yes.
All right, would you like to come up briefly?
All right, so both sides having closed the portion of the evidence, the next step is for me to read the charge to you. After I've read the charge, and it's rather lengthy, but you will be able to take the charge of the court back with you. We'll have closing arguments. After closing arguments is when you will begin deliberations. So I'm going to read this, and as I said before, it is rather lengthy. But you will be able to take the original back with you. Charge of the court. Ladies and gentlemen of the jury, the defendant, Uriah Urick Jr., stands charged by indictment with the felony offense of capital murder, alleged to have been committed on or about the 6th day of February 2025 in Galveston County, Texas. To this charge, the defendant has pled not guilty. Both sides will soon present final arguments. Before they do, I must now give you the instructions you must follow in deciding whether the defendant has been proved guilty or not. You will have a written copy of these instructions to take with you and use during your deliberations. First, I will tell you some general principles of law that must govern your decision of the case. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles, the indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have to prove anything. So he does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. It is not required that the state prove every element of the offense beyond all possible doubt. It is required that the state's proof excludes any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. Jury as fact finder. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and the weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with the case that is not evidence in the trial. Statements made by lawyers are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of the testimony of the witnesses and the materials admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. You should consider only the evidence. You are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Testimony. Certain testimony will be read back to you by the court recorder if you request. To request the testimony be read back to you, you must follow these rules. The court will allow testimony to be read back to the jury only if the jury, in writing, signed by the foreperson, 1, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witnesses who made the statement. The court will then have the court recorder read back only that part of the statement that is in disagreement. Evidence of wrongful acts possibly committed by the defendant. During the trial, you have heard evidence that the defendant may have committed wrongful acts not charged in the indictment. You are not to consider that evidence at all unless you find, beyond a reasonable doubt, that the defendant did, in fact, commit the wrongful act. Those of you who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person, and for this reason was likely to commit the charged offense. In other words, you should only consider this evidence only for the specific limited purpose I have described. To consider this evidence for any other purpose would be improper. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go to the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss the case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss the case unless all of you are present in the jury room. If anyone leaves, then you must stop your discussions about the case until all of you are present again. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this time is to determine whether the defendant has been proved guilty. You must restrict your deliberations to this matter. If you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to that particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. No one has the authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through the officer who has you in charge. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. After you have reached a unanimous verdict, the foreperson will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as foreperson. Occasionally, during jury deliberations, a dispute arises as to the testimony presented. If this should occur, you shall inform the court and request that the court read the portion of the disputed testimony to you from the official transcript. You shall not rely on your notes to resolve the dispute, because those notes, if any, are not official transcripts. The dispute must be settled by the official transcript, for it is the official transcript rather than any juror's notes upon which you must base your determination of the facts and ultimately your verdict in this case. Certain testimony will be read back to you by the court recorder if you request. To request the testimony be read back, you must follow these rules. The court will allow testimony to be read back to the jury only if, in writing and signed by the foreperson, 1, states that it is requesting the testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witnesses who made the statement. The court will then have the court recorder read back only that part of the statement that is in disagreement. Any notes you have taken are for your own personal use. You may take your notes back into the jury room and consult them during deliberations, but do not show or read your notes to your fellow jurors during your deliberations. Your notes are not evidence. Each of you should rely on your own independent recollection of the evidence and not be influenced by the fact that another juror has or has not taken notes. Instructions of the court. The state accuses the defendant of having committed the offense of capital murder. Specifically, the accusation is that the defendant is guilty of capital murder. The state contends that the defendant intentionally caused the death of Tammy King by shooting Tammy King with a firearm, and the defendant was in the course of committing or attempting to commit the offense of robbery of Tammy King. A person commits an offense if the person intentionally causes the death of an individual in the course of committing or attempting to commit robbery. To prove that the defendant is guilty of capital murder, the state must prove beyond a reasonable doubt two elements. The elements are that 1, the defendant intentionally caused the death of an individual, and 2, this was done in the course of committing or attempting to commit robbery. A person commits the offense of murder if the person intentionally causes the death of an individual. To prove the defendant guilty of murder, the state must prove beyond a reasonable doubt two elements. The elements are that 1, the defendant caused the death of an individual, and 2, the defendant did this intentionally. A person causes the death of another if, but for the person's conduct, the death of the other would not have occurred. Burden of proof. The state must prove beyond a reasonable doubt the accusation of capital murder. Definitions. Intentionally causing the death of an individual. A person intentionally causes the death of an individual if the person has the conscious objective or desire to cause that death. Individual. Individual means a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth. Robbery. A person commits an offense of robbery if, in the course of committing or attempting to commit theft, and with the intent to obtain or maintain control of the property, the person either 1, intentionally, knowingly, or recklessly causes bodily injury to another, or 2, intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. In the course of committing or attempting to commit theft. In the course of committing or attempting to commit theft means conduct that occurs in the attempt to commit during the commission of or an immediate flight after the attempt or commission of theft. Theft. A person commits the offense of theft if the person appropriates property. Number 2, this appropriation was unlawful in that it was without the property owner's effective consent. And 3, the person did this with the intent to deprive the owner of the property. Attempt to commit theft. A person attempts to commit theft if the person, with the specific intention to commit theft, does an act amounting to more than mere preparation that tends but fails to effect a theft. Intent to cause serious bodily injury. A person intends to cause serious bodily injury to another if it is the person's conscious objective or desire to cause the serious bodily injury to another. Bodily injury. Serious bodily injury means bodily injury that creates the substantial risk of death or that causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Application of law to facts. Although the state has charged the defendant with the offense of capital murder, you may find the defendant not guilty of the charged offense, but guilty of any lesser included offense. In this case, murder is a lesser included offense of the charge and greater offense of capital murder. You may discuss both offenses in any order you choose. Before you may find the defendant guilty of murder, however, you must first find him not guilty of capital murder. Now, bearing in mind the foregoing instructions, If you find from the evidence beyond a reasonable doubt that on or about the 6th day of February, 2025, in Galveston County, Texas, the defendant, Uriah Urick Jr., did then and there intentionally cause the death of an individual, namely Tammy King, by shooting Tammy King with a firearm, and the defendant was then and there in the course of committing or attempting to commit the offensive robbery of Tammy King, then you will find the defendant guilty of the offense of capital murder. If you all agree that the state has failed to prove beyond a reasonable doubt the defendant's guilt, then you must find the defendant not guilty. If you all agree that the state has failed to prove beyond a reasonable doubt any of the elements listed above, you must find the defendant not guilty of the offense of capital murder. You may then determine whether the state has proved beyond a reasonable doubt the lesser included offense of murder. Now, if you find from the evidence beyond a reasonable doubt that on or about the 6th day of February, 2025, in Galveston County, Texas, the defendant, Uriah Urick Jr., did then and there intentionally or knowingly cause the death of an individual, namely Tammy King, by shooting Tammy King with a firearm. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either capital murder or murder, but you have a reasonable doubt about which of the offenses he is guilty, you must resolve the doubt in the defendant's favor. In that situation, you must find him guilty of the lesser offense of murder. If you have a reasonable doubt about whether the defendant is guilty of either offense, then you must acquit the defendant and say by your verdict, not guilty. Suitable forms for your verdict are hereto attached. The verdict must be in writing and signed by your foreperson. Your sole duty at this time is to determine the defendant's guilt or innocence of the defendant under the indictment in the case and restrict your deliberations solely to the issue of guilt or innocence of the defendant. The verdict. The law requires that you render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court in writing. Signed, Patricia Grady, presiding judge of the 212th Judicial District Court. The verdict sheet reads as follows. Verdict of the jury. Paragraph 1. We, the jury, find the defendant, Uriah Urick Jr., guilty of the felony offense of capital murder as charged in the indictment. Second paragraph. We, the jury, find the defendant, Uriah Urick Jr., guilty of the lesser offense of murder. Final paragraph reads, we, the jury, find the defendant, Uriah Urick Jr., not guilty. And each paragraph has a signature line for the foreperson of the jury. Half an hour?
Sorry about the state, Your Honor.
Okay. Go ahead and get started.
Thank you, Judge. May I use the Elmo?
Yes, sir.
So, ladies and gentlemen, I'm going to be very brief with you guys here. There's only 3 things I really want to address with you before I'll turn it over to Mr. Agnew and Ms. Willis. The first thing I want to address is the on or about the 6th day of February 2025. I zoomed in there to make it a little bit easier. This is just the first page of the jury charge. The reason I want to address this is because in the indictment it's been alleged that the offense took place on the 6th of February, as it says. But there's been a lot of testimony that states the 5th of February, or perhaps even the 7th. It's a little bit unknown. The reason that we can't really have a precise date is because Miss King's body was discovered long after she was actually murdered. However, the law does not require us to prove specifically an individual date. That's why it has the language on or about. Now here, it's about a 1 day difference between what's been alleged in the indictment and what the testimony has been. But in capital murder, because there's no statute of limitations, as long as we proved beyond a reasonable doubt that the murder happened before the case was indicted, it's still legally sufficient. So just because there's a 1 day difference, there is no reason to render a not guilty verdict. That's the first thing I wanted to address. The second thing I want to address is robbery, which is what makes this case a capital murder. And specifically, this is on page 8 of the jury charge, by the way. Robbery is a theft that takes place or is attempted, and in the course of committing it, they either cause bodily injury or threatened bodily injury. Now, in this case, a bullet wound to the head is certainly bodily injury. It would probably be more accurately described as serious bodily injury, but bodily injury is kind of like a lesser included offense of serious bodily injury. So we have that one down pat. One of the issues that might arise, it might be confusing, is whether or not there's a specific order between the robbery and the murder that needs to take place in order to find a capital murder. For instance, whether or not she had to be aware that she was being robbed before murdered in order to get to capital. She doesn't. As we see here, in the course of committing or attempting to commit theft, there's a definition that has 3 separate time frames for the committing or attempting to commit theft. The first is in an attempt to commit theft, which means before the theft occurs, bodily injury takes place. So if she's unaware that the theft is being attempted and she is shot in the head, it's still robbery. If she is actively being robbed and during the commission of the theft is shot in the head, it's still robbery. And if after she had been stolen from, she had a thing stolen from her in the immediate flight afterwards, it's still robbery. So whether the murder took place before the robbery, during the robbery, or after, it's still a capital murder offense because it happened in the course of committing or attempting to commit theft. Now, lastly, what I want to address is going to be on page 9 of the jury charge. Before you may find the defendant guilty of murder, however, you must first find him not guilty of capital murder. So this is just a note on how your deliberations should proceed. You have to start on the issue of capital murder first. And until you have a unanimous decision on whether or not he's guilty or not guilty of capital murder, only in the event of a not guilty on that charge do you even begin your deliberations to the lesser included offense. So you have to start with capital murder. With that, that's all I really wanted to tell you. Make sure you guys understood. I will now turn it over to Mr. Agnew for him to make his arguments.
You have half an hour, Mr. Agnew.
Thank you, Your Honor. May it please the court, Ms. Willis, Mr. Reinhardt. On February 4th of this year, we had a 17-year-old girl and we had an 18-year-old boy. And what they wanted was to be an adult. They wanted to be grown up. What they found out very quick after that is sometimes it's best not to get what you want, because they realized that they weren't prepared to be adults at that point. One of the things I want y'all to do when you go back there and you go over all the text messages and Instagram messages and all those messages is look, I'm not saying that it was right, but they hated her. They absolutely hated her, and they hated living with her. I mean, again, I'm not trying to say that she was a bad person. I don't mean that at all. She's obviously a good person. She took in her 17-year-old, much younger than that, daughter. But Tara obviously had to have some problems in her family to end up having to live with Grandma. And Grandma was gracious enough to take her in. And she ends up being repaid in a horrible fashion. But the thing is they thought that they were ready to be adults. And if you read the messages, they had a lot of hatred towards her. And they sort of fed each other. They fed the monster, and they went after her. But if you also look at their messages and you look at the videos, they had access to all that stuff before this ever happened. And they did. They had access to the guns. Why else would there be a gun behind the couch? It wasn't in the safe. It was out. They had access to the codes. And they could say, well, it was on a piece of paper, you know, in a dresser or whatever, but they had access to that. They did from the word go. There's a text, if y'all remember, or an Instagram message where they refer to, you know, about basically the fact that, you know, grandma hasn't tried to tighten up the money thing yet. That she was still being very free with them with the money. I'm not asking y'all to find my client not guilty. I mean, I'm not asking you to do that at all. What I'm asking you to do is look at the facts. And I understand where they're coming from with the robbery and all that other stuff, but they actually did have access to all that stuff. They did all along. And they didn't kill her to take her stuff. And they didn't. The reason they killed her is because they were, in all honesty, they were incredibly naive. And they were also, if you remember, they were also using meth. And that has a tendency of doing very bad things to your brain. It's not an excuse, but it does bad things to your brain. But they weren't killing her to rob her. They were killing her because they wanted to be adults. And think in terms of what Tara said when they were talking about, because they were talking about killing her. There's messages all over the place. You know, y'all saw them, I saw them. They were all there. But what did Tara say was one of the things that she wanted to take with her? Her stuffed animals. She wanted to take her stuffed animals. What did she not take with her? Her stuffed animals. She realized very quickly, as they both did, they were not prepared for this life. They couldn't drive. They didn't have jobs. They had nowhere to live. They had to depend on other people to come get them. They depend on other people to get rid of stuff. They made a decision that not only ended one life, but effectively ended three. Because they were not prepared for the situation that they put themselves into. And no matter what y'all do, their lives are over. And it's by their own hands. I'm not going to try and excuse that. Their lives are over. It's just going to be a matter of how. How over are their lives? And that's the decision that y'all have to make when you get back there. Like I said, you're talking about an 18-year-old kid. He was less than a month being 18 years old. And he made the absolute worst decision he could possibly make. And I'm not trying to excuse him. And I'm telling you that right now. I'm not asking y'all to find him not guilty at all. What I'm asking you to do is to go back there and find him guilty of murder. Because like I said, from the word go, they had access to all this stuff. I mean, Grandma's 62 years old. I'm sure she ran a pretty loose ship as a parent because that's not a grandma's job. Grandma's there to be fun. They're supposed to be fun. That's why most everybody loves their grandmothers. And moms are supposed to be a little bit more stern. And she had to go from being grandma to mom at an older age than I think most people want to do that. And Tara didn't like it, and Uriah didn't like it. Not saying that what they did was right. It's not right at all. What they did was horrible. But I think at this point, when you look at it, to say that they killed her to take her stuff is wrong. They killed her because they wanted to be adults. They wanted to be on their own. And immediately learned they weren't prepared for it. And they weren't. They learned real fast. Sometimes it's best not to get what you wish for. And the thing is they're going to have to live with that for the rest of their lives. I know this has been a really, really long week. And I apologize to y'all for that. This has been a long week for all of us. I appreciate every single bit of attention that y'all have given to all of us during this process. And I mean that in all sincerity. But when you go back there, I'm asking you to please find him guilty of murder and not the capital murder. Thank you very much for your attention, and I look forward to your verdict.
Ms. Willis, you have 26 minutes remaining.
Yes, Your Honor, may I utilize the overhead?
Yes.
They killed her because they wanted to be adults. If she comes in, I'll kill her. Can I kill her at 4? I have an inch of hundreds. I'm going to kill her. On and on and on and on and on. Mr. Agnew just said that they killed her because they wanted to be adults. That they didn't kill her to rob her. Don't take my word for it. Take Uriah's. I go in, threaten to get any and every phone. They did that. Tell her to move, grab the key ring out of her room, tell her to open everything I haven't. We know those safes are open. He's admitting he'd already opened some. Kill her when done, get someone to drive the Ford. They killed her, and they got a ride. To say that Tammy King is dead because she had to be a mom and they wanted to be adults is so disrespectful to Tammy King's life. This woman took in her granddaughter, raised her since she was young. It does not matter what happened to make Tara King be living with Tammy King. Families have different situations all the time. That does not give anybody the excuse to shoot Tammy King. Tara lived with her grandmother for her entire life, and things were fine. Where it went south, where I told you that that young love turned into something dark, was when that man came into her life. He is young. He is 18 years old. But in this country, that makes you a man. He is an adult. That thing that his defense says he wants to be, he is. And he has to face the repercussions of his decisions that he made as an adult. This was a thought-out plan. This was a fantasy that turned into a need, that turned into action. We see, as early as November, when Tammy's out of the room, they're seeing what's in those safes. They're taking pictures of the safe codes. They're setting up their ability to execute their plan. You see that moving into 11 days prior to the murder, the 26th of January, they start talking. This is what we need to do. We need to kill her. We need to rob her. We're going to take these antique coins. We're going to take this money. The other thing Mr. Agnew talked about was that they had access because there was guns behind the couch. There were guns behind the couch that were still there. Any of you who have lived in a home, just because you have access to something does not mean you have permission to take it forever. Does not mean you have permission to murder someone to take their items. Access, we can give to Tara King because she lived in that home. Still doesn't give her permission to take things. Still does not give her permission to go into safes. You know who didn't have permission to live in that home? The man squatting under a desk in a teenage girl's bedroom, peeing in urine bottles to hide from the owner of the home. That's not access. That's squatting and robbery. You saw as it got further in time that yes, Tara and Uriah started utilizing drugs. They hated Tammy King. Hated her. That is not an excuse for murder. That is not an excuse for robbery. You saw through the Cash App returns that Detective Scott testified to that Tammy actually gave any money that Tara needed to her. If she requested something, she got it. Taco Bell, a phone case. That didn't mean she got the $10,000 that her late grandfather had left her. It was an inheritance. She had to wait. This was impatience and greed. You saw the firearms. These are not run-of-the-mill cheap firearms. These were nice firearms. You heard Detective Hudson testify to they were expensive firearms. They were valuable. They knew they were valuable, and you can see that from their messages offering to sell them to people. That was a cash value for them. We'll give you $1,000 or guns for a ride. We'll give you guns or $300 to stay the night. And as those 11 days leading up to February 5th came, you see their plan get more and more substance. You see Tara say, we need a few days and a stable plan. I want to pack. And yes, she wanted to pack her stuffed animals, but they also wanted to pack the guns and the cash and the antique coins and their methamphetamine. They wanted to pack all kinds of stuff. Her wanting to pack stuffed animals does not absolve them. As those days moved closer, you see Uriah begin begging to commit this plan. It stopped being a fantasy. It stopped being a desire. 3 days before, I went to watch a 5.56 shred through someone's skin in slow-mo. He only had to wait 2 days to watch that come to reality. When he picked up the 5.56, and he pointed it at Tammy King's head, and he pulled the trigger. He made his fantasies reality. We get closer. I'm going to kill her. I hope I get an excuse to kill her today. Can I kill her at 4? Let's do it at 5. We're going at 7. We ride at dawn. This was planned. This was intentional. As Mr. Reinhardt told you, the order in which these things happened doesn't change that they happened. That safe was emptied. You hear testimony from Mr. Utton that they did not have access to that safe. Those guns, that money, it all belonged to Tammy King. That safe was empty. You heard that from Investigator Martin. You heard that from Detective Hudson. You heard that from Detective Espinoza. You heard that from Detective Bernard. It was emptied. It was gone. The initials on the items that were in there, the ammunition boxes, said J.K. It was J.C. King. It was Tammy's husband. More than just seeing this, you saw Uriah already trying to formulate what excuse he would give. When he's talking to his friend Jaden Landry a few days prior, he's talking about if he kills someone else, he'll just say it's self-defense if someone came into the house. It's convenient. Because what's the first thing that he said to his mother when he called her from Laredo? It was self-defense. She was going to stab Tara. You have heard absolutely zero evidence that Tammy ever laid her hands on Tara, that Tammy ever attempted to stab Tara. Tammy is laying naked in her bed. His words to his mom are, it was self-defense. But he already had told Travis, it doesn't look like self-defense though. Because it's not. A lesser of murder would be an injustice in this case. Because so much more than just Tammy's life was taken. Yes, 3 lives are permanently affected by this. But so are many, many others. All of the items that got systematically taken from Tammy King, the antique coins that were in their backpack in Laredo, the $5,400 still in crisp $100 bills that came from those inches of hundreds that he talks about, that stack of money Rigoberto saw him pull out, start calling friends over as soon as the murder was done, that is robbery. The robbery, the theft that occurred while causing bodily injury. As Mr. Reinhardt told you, bodily injury absolutely counts when you have a gunshot wound to the head that is fatal. Uriah Urick launched a plan. He had his dark fantasies, he had his dark desires, and he moved forward. He begged and begged until he had his opportunity, until he had his excuse. He had his ride set up. He had where they were going. He had all the people he could reach out to. And on February 5th, 2025, he went into Tammy King's room and he shot her in the head. He covered her with linens so that Tara didn't have to see the face of her dead grandmother while they robbed her blind. And then they sat there for hours in the home with Tammy King's body while they waited for a ride. Then they ran away to Laredo, where you see them still calling and texting people. You see messages like, "This is the start of the rest of our lives. We're making bank," and live happily ever after. There is no other verdict appropriate in this case than guilty on capital murder. Thank you.
So at this point, you have heard all of the evidence. You've received a charge of the court, and you have heard closing argument. I'm going to hand the verdict sheet to Deputy Flynn, and once you are all assembled, except for the alternate, you may begin your deliberations.
All rise for the jury.
Court stands in recess until we have received a verdict. The court has received a jury communication. After consulting with the attorneys, it appears that the request is merely exhibits that they're requesting. So the court is going to attach all exhibits responsive to the request, and it's in the back. Is everyone good with that? Anything for the record?
That's fine with me, Judge.
Okay, very good. Then we will send all of these back. Let's go off the record. Attorney, the state is also present. The court has received a communication that a unanimous verdict has been reached. seated. And at this time, I will ask the foreperson, have you reached a verdict in this case?
Yes, we have.
Is that verdict unanimous?
Yes, it is.
Please hand the verdict sheet to Deputy Flynn.
Sir.
Mr. Urick, please stand.
State of Texas versus Uriah Urick Jr., clause number 25 CR 0515. We, the jury, find the defendant Uriah Urick Jr. guilty of the felony offense of capital murder as charged in the indictment. Signed by the foreperson of the jury.
Mr. Agnew, would you like to have the jury polled?
No.
All right, you may be seated. So, ladies and gentlemen, at this time, your service is complete. I'm going to ask you to walk back with Deputy Flynn, and I'll visit you in a minute.
All rise with
At this time, may I see the attorneys, please? In the Urick matter. So I'm going to ask you to please stand. So, Mr. Urick, you came before this court and a jury and entered a plea of not guilty to the offense of capital murder. The evidence was presented to the jury. A jury was charged, and after deliberating, the jury returned a verdict finding you guilty of the offense of capital murder. Is there any legal reason why sentence should not now be pronounced against you? Any legal reason? All right. Having no legal reason, I see you shaking your head no, and that's correct. There's no legal reason, correct?
Correct.
All right. It is the order of this court that you, Mr. Urick, who have been adjudged guilty of the offense of capital murder and whose punishment is assessed at life in prison, that you be delivered to the sheriff of the Galveston County Jail, who will then place you with the director of the Texas Department of Criminal Justice Institution Division, where you'll be confined for the rest of your life in accordance with the laws governing the Department of Criminal Justice Institution. So you are now remanded to the custody of the Galveston County Sheriff, who will remand you to the custody of Texas Department of Criminal Justice. And any time you have will also be given to you. It appears that you have 272 days credit. That credit will be given. There's also going to be an entry of a finding of a deadly weapon, namely a firearm. Because you are indigent, I will waive your court costs. And because this is a plea bargain, because this is not a plea bargain, you do have the right of appeal. And I will take notice of the fact that you have indeed filed a notice of appeal, and the court will appoint an appellate attorney to help you. Anything further for the record? Okay.
County from the state now.
And we do have a dismissal for the credit card.
That is correct, Your Honor. I will say, Your Honor, the discovery receipt is still loading to be printed, and I will give that to the court as soon as it is done printing.
Okay. Anything further for the record?
No.
Okay. The proceedings are concluded and the court stands in recess. Thank you.
Thank you, Your Honor.
Here you go, Flynn. You go.